Hello everybody, it's Mark Sage again, the Executive Director of the AREA, Augmented Reality Enterprise Alliance. And welcome to our latest of a long line of webinars looking at the XR space. I'm really excited about this webinar. I've been lucky enough to kind of see some of the work of our presenters today. And it's about an area that we don't pick up too often when it comes to AR and VR. It's around the kind of legal issues. I'd like to hand it over to Eric and Moritz, but over to you guys, if you can maybe introduce yourself and a bit about the company, and look forward to your insights. Thank you very much indeed.
Yeah, will do, Mark, and thank you very much for having us today. It's a great pleasure, and welcome to all of you. We really look forward to our today's webinar here. Yeah, my name is Marc Wagner, and together with my colleague Moritz Stilz, I will guide you through the presentation today, try to answer all of your questions. We are both lawyers at the German law firm Gleiss Lutz. We are amongst the top 3 law firms in Germany, and we are seen as one of the strong leaders in the field of virtual reality and also artificial intelligence. So we were amongst the very early adopters by ourselves. So we opened up a metaverse office already a couple of years ago, and this was a great story of success. And of course, we also thought about a lot of the legal questions that are kind of governing the rules and all the operational steps you want to take when entering augmented reality, extended reality, or also virtual reality. And I would say this is what we want to tell you during our webinar today and during our presentation. So, of course, we understand that many of you, most likely most of you, do not have a legal background. And so we will try to keep it from a legal perspective as simple as possible. But whenever dealing with any issues around augmented reality, extended reality, or also virtual reality, there are of course, a lot of legal issues circling around this topic. And so we want to provide you with kind of a, let's say, basic awareness of what kind of pitfalls are to watch out for and what kind of legal boundaries exist. And so if you look at the agenda for today, we will give you a short introduction, let you know, from a technical and legal perspective, how things are falling together in this particular field. And on the basis of this, provide you with kind of an overview on the legal landscape. You will see that is a very broad and rather complex landscape. So since we have only this 1 hour for the webinar, and we want to leave some time for your questions at the end, we will select some examples and dig a little bit deeper into some of the relevant legal issues, like intellectual property issues, like data privacy, which is of course a very important issue, and to give you also kind of a feeling what things might be triggered by the use of VR and XR technology, also product liability and user safety perspective. Yeah, this is not comprehensive, but it's, I think, a good selection to give you a basic understanding of how many legal issues are tackled in this regard. And at the end of our presentation, we want to provide you with a quick outlook. And when we think about this topic, then we also have to think about AI, which we have not put in the headline for our today's webinar. But I think you all know it's kind of a natural fit. Yeah, so you can use AI for generating content. You can use AI for using data or misusing data, to some extent, and of course many things more. And so we want to give you also a quick update on what's on the horizon in regard to this and how things fit together with regard to virtual reality and the other stuff. So this is the program for today, and I think we start right away and start with the legal landscape and a brief introduction. And Moritz, I would hand over to you for this part.
Thank you, Eric, and thank you, Mark, and welcome everybody. And as Eric said, we just want to give a brief outlook or identify a couple of pitfalls in the way we lawyers think about something, because we are strong believers in the concept of compliance by design. If early in the development process legal challenges are identified, there are usually ways to address them better than at the end a lawyer comes at the product right before launch and says, oh, well, that's a problem and that's a problem, which again, we are problem solvers and enablers and not prohibitors. After this rather abstract thing, the question is it, when I was speaking with a colleague the other day, he asked me, well, it's a new technology, so the law is new, so there are a lot of questions that are unresolved. And everybody here knows, I think, it's not that new. It's now 12 years ago that Google debuted their VR glasses, the Google glasses. The Guardian calls me out here for citing an article that's more than 9 years old. And even on the Fashion Week, they debuted. So the question is, what is new? Like, why is it now in 2025 an interesting topic to talk about it? And here, this is just one example, which will follow us a little bit through the presentation. The use cases and the applications. Here you see a gentleman driving in the United States with a beautiful Tesla Cybertruck wearing the Apple Vision Pro. And obviously he's using the full self-driving, as you can see in the enlargement, because he doesn't have both hands on the wheel. Obviously, this creates all sorts of challenges, but after this rather catchy example, I want to take one step back and show you or explain how we lawyers think about something like this and how we think about the technology. And in particular, what's the challenge? Here I am sitting, and I would prefer, obviously, to sit with you all in a room. And like you this morning and I all day, we process all sorts of data. When I was driving to work, I was operating my car, I was seeing other cars, I was meeting my boss, I was having a coffee, I was hearing. I'm processing a lot of information daily. And I'm not wearing any kind of glasses right now, although I should. And from a legal perspective, that's totally fair game. So it's totally fine that I think about, oh, my colleague, he looks younger than yesterday, or oh, my colleague looks tired, or oh, this really sounds strange. So this is all fair game. In Germany, we have a little poem that says the thoughts are free. So lawyers are rather relaxed when it comes to processing data just by yourself. It's the way our brain works. So what changes is the question when you wear VR glasses, when you wear XR glasses. Is it really a difference? And yes, it's absolutely a difference from a lawyer perspective, because all of a sudden you will face questions about data privacy, intellectual property, regulatory, liability, and there are many, 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 many more. And why? What makes the difference? And the difference makes that I'm not processing it myself, but through a device. And adding this device in the mix makes things from a legal perspective way more interesting, or you would probably say more challenging and problematic. So taking one step further back after now explaining, okay, the moment you wear a device, a lot of legal questions arise. So what kind of legal questions? Are they limited to a certain field? And the answer is pretty much everything. Pretty much everything, ranging from commercial litigation, which Eric is the European expert about it, we'll touch upon in a minute, regulatory AI Act, Data Act, to labor law, worker safety, Eric will also touch on that one, compliance investigations, data regulation, privacy, everything. So, and this is what I think Eric and I and Marc Ruttloff as well are very focused on. We always want to start with the technology and a deep understanding of the technology before applying the law to it, because what usually happens, people with a limited understanding of the technology reach conclusions, and then it's a little bit of work to convince them how actually the technology works. So don't get deterred from this little outlook of all the different fields of law. There's a solution for almost everything. To take just some prominent examples out of it, I want to quickly start with IP and copyright. Obviously, we're a German law firm, and I will tell you a little bit about the German Urheberrechtsgesetz, but it's very similar in the US for the copyright. And obviously, the first question is, why is it relevant? So I am now, and this is an older picture that I generated with AI, we have here a gentleman looking at a piece of art in the museum through XR glasses or augmented reality glasses. So he sees it through. Would he not be wearing glasses? I would go back to sleep as a lawyer, because it's fine. I can go in a museum and I can look at art. The moment he wears this, we come into the legal territory. What kind of legal territory, you might ask? Well, the moment he looks through the glasses, he sees the piece of art in his glasses. And technically, from a legal perspective, it's a reproduction, because of course the device sees the picture and reproduces it on the screen. And at that moment, the question is a consent or justification for processing this required? We will hear a lot about the concept of processing just in a second in data privacy, but it's also the same for copyright. But yes, the first answer is we need a justification. We need a reason to do this. And the first one you might think about is a temporary reproduction. If you just see something see something while passing for the whole purpose of reproduction, typically you have it on a television. If you have a smart device that is like streaming a movie out of the internet or something else, that's just a transit or incidental reproduction and has the sole purpose of enabled transmission. The question here, does him wearing the AR or VR glasses have an independent economic significance? Is it an economic significantly that he's seeing it through it? Is it an added feature? And this is where it also becomes very important. We have two things that I want you guys to remember from like the way we lawyers think about it. One is sometimes less data means less problems. And the second one is marketing matters. Because the way we lawyers will go about this is we will look at the marketing and the advertisement. We will look and see, oh, well, look, in the advertisement it says you can see art, and this is then digitally enabled, and it's 3D, and all sorts of stuff. And we will say, look, this is a marketing feature. Why did you put it into marketing? Because you want to attract customers with it. That's why it has economic significance. And that's why it's not an allowed temporary reproduction. Here, and we think back to our friend in the Cybertruck, he's driving, or the car is driving, it's full self-driving, allegedly. There's an exception for works in public spaces. Obviously, we in Stuttgart, Germany, we have a very famous, at least famous in Germany, train station, which will be very fancy in 50 years or so. If you wear VR glass and you walk by and you see it, that's a work in public spaces, that's fine. But again, it's in public spaces. It's not in private spaces, not in the museum. And then you have the right to private copies. But this is, again, you need for private use. And for VR applications, AR, MR applications, of course, that can be an interesting use case, but more interesting is to use it for economic purposes. So we just remember, sometimes less features mean less problem. If there is a device that doesn't have the see-through capability, fantastic. If it has the see-through capability and portrays everything, you need to ask yourself, well, do I have the copyright for everything I see? Here we quickly touched about it already. The application here, he's driving. I think he would argue when he's being stopped that these are like the works in public space. But again, also the inner works of his Tesla he sees, and he's being reproduced on his Apple Vision Pro. To make matters more complicated, I want to touch on everybody's favorite topic, and that is data privacy and security. Data privacy, of course, Europe has been the forerunners. I'm very confident and happy to hear that California is catching up and other states in the US. But Europe has been the forerunner of data privacy regulation with the GDPR. I think everybody has heard of at least something about the GDPR. And I think everybody has remembered one thing, or at least that would be the other thing that I would suggest to remember is personal data. What is personal data? Because it only applies to personal data. And the answer is everything. It's not sensitive data. It's not commercially sensitive data. It's anything that relates to a person. And even if it doesn't carry a name, if it can be used to identify me, then it's personal data. Meaning my face, meaning my bank account, meaning an email, meaning my name, everything. And the GDPR applies for the processing of personal data. So the question is, who's processing? So we remember again our gentleman driving around in the Tesla. And he's looking at me. I'm driving in the car next to him. I don't have a Cybertruck. I just have a VW Golf. And he sees me. And he sees me in his Apple Vision Pro. So who's processing the data? Is he processing the data right now? Is it Apple? Is it the app developer that it's running? Is it Tesla? So these are all questions you need to think and need to address about when thinking about applications. Again, we have the challenge because the Apple Vision Pro has a see-through capability. And that's why, frankly, it took longer to get it to market in Europe than in the US. You remember it launched, I think, a year later in Europe than in the rest of the world because of GDPR, because of these kind of issues. So we remember personal data is everything. Processing of personal data is whenever you do something with it, and then you need a legal basis for processing. Again, I come back to my morning. This morning, I processed a lot of personal data, but if I do that myself, for my purely personal reasons, I'm out. That's not covered. That means everything else is covered. So any commercial reason, anything is covered. And here in Germany, we have now dash cams. Dash cams are are famous everywhere, and people are using it also in the US. And there you can ask your question, is it, for example, purely personal? And is it processing of data? Because a dash cam just overwrites and overwrites and overwrites. However, some data privacy authorities in Europe, and that's the beauty in Europe, that there are many, many different authorities applying the same GDPR, have imposed bans, have said this is processing, and this is not just for personal reasons. Why am I using the dashcam example? Because in devices like Apple Vision Pro and others with see-through capability, you're recording and you're displaying and you're not saving it. You're overwriting it all the time. However, I just want to raise awareness, this can be processing. So you need to think about data privacy. There are many ways around it and many ways to navigate it, but that's where the first lawyer will come, oh, it's good that we talk about it, because in that moment you see it. Meaning, if you're a software developer and you do not need the see-through capability, you have one less problem to think about. So that's why we just wanted to raise it. Again, here, the way data privacy experts think about it, whenever there's something being analyzed, something being done, something being thought about, it's processing. And processing is not per se illegal. You just need a legal basis for it. And there are essentially two ways to do it. And for example, if you have an application for training, industrial training is fantastic and super useful. Consent is an easy solution. If the employee gives their informed consent and voluntary, it's legal to process the data. Totally fine. But again, think about it in the environment. So Eric, Mark, and I are standing around the machine, and you're wearing the glasses, and you look at all of us. We all need to give our consent. If we don't give the consent, there's also the way, of course, for after balancing of interest, if the employer says, yes, after balancing my rights as an employer who's standing next to the machine, compared to my interest as a company to train my individuals and my employees as efficiently as possible, my interest ranks higher, and that's why it's legal to do it. You can navigate all these issues. You just need to identify them and then document your balancing in your decision. And then this will make the process a lot easier. And again, the last thing I wanted to close this little chapter is less data, fewer problems. That applies for IP. It also applies for data protection. So sometimes a feature that is not really necessary for the business case can sometimes create a lot of problems and cost a lot of lawyer time, which is usually a little bit expensive. Again, here, less features would create less problems. I think it's best summarized in this car. If it wouldn't be see-through, it wouldn't be full self-driving. But yes. And with that, I would hand over to Eric to talk about product liability and user safety.
Yeah, thank you, Moritz. Product liability and user safety are in principle closely related to each other, but still they are seen as different topics, because when it comes to user safety, you have to think about principles in a work environment, safe work environment, and we have, for example, specific laws in place which help to protect workers from any kind of dangers. When we speak about product liability as such, then we speak about all kind of relation and interference, so all kind of harm that is caused between third parties or even contractual parties. And so you have to think these things together. When we speak about product liability, and some of you might know that we have kind of a harmonized legal framework within Europe. We had in the year 1985 already, which is quite a while ago, the adoption of the Product Liability Directive, which was fully harmonized within the European member states, which meant that all member states had to implement similar laws in their respective jurisdiction, their respective country. And this is why we have, for example, in Germany, a Product Liability Act, which is reflecting the European standard also for Germany as a member state. And in the other member states, the same applies as well. Now, you can imagine that in the year 1985, virtual reality was not such a big issue. So the European lawmaker back in 2022 thought about modernizing the law a bit, even though it was formulated in an abstract way. And of course, we lawyers are trained to use very abstract provisions and try to apply them on a factual basis, which might significantly change over time. The European lawmaker thought it might make sense to modernize the law, and in particular against the background of the digitalization of the world and also the implementation of virtual reality software components, AI and other stuff like that. It took some time, but in the end of 2024, the Product Liability Directive in its new version was implemented, and so on the European level. And then there's a 2-year period running for all member states to implement it in national laws. So the period is still running, but from 9 December 2026, all member states within the European Union shall have similar regulations in place, which reflects the new standard which the European lawmaker has defined in this regard. And in order to understand what has changed and why this new standard makes it more dangerous for companies doing business with regard to virtual reality, extended reality, and other products like this, we would like to start with a short case study. And in this case study, a company A, is using the software of the software manufacturer S on a VR device, VR glasses of the manufacturer M. And this setting is used to control a machine by employees of company A. And now, due to a malfunction of the VR glasses or due to an error in the software or both, you never know. This is one of the tricky parts when it comes to product liability. Often it's not so clear what is the root cause in the respective case. An employee or also a third party gets injured by the machine. So now the question is, who is liable? Is the company A? Is it the manufacturer of the software? Is it the manufacturer of the VR glasses? Or are there a joint and several liability amongst the three entities? If you look at this and look into it from a legal perspective, you start to look at the different legal entities that are involved. And if you look at this sheet from the right to the left, we have the damaged third party, as I said, for example, an employee or also another third party. And then we have company A, which has used the overall setting, and part of it was delivered by device manufacturer M and software developer S. And of course, they did not all the work by themselves, but they have supply chains in place. So usually you have then sub-suppliers producing parts of the hardware or providing part of the software as well. So, and if you look at this then even closer, then you can see you have, of course, contractual relationships in place between the third party and the company, maybe not mandatorily, but maybe between the company and the device manufacturer and the software developer, of course, and then along the supply chains, a similar contractual relationship. And usually, if you have a contractual relationship, it is rather easy to bring a claim under this contractual relationship if you get harmed by your contractual partner. So in these cases, product liability law is often not so relevant. On the other hand, the limitation period for such contractual claims are usually rather short, and product liability claims have a much longer limitation period. We are speaking of time periods of 10 to 30 years, yeah, so really a very long period of time. And so these claims, in particular product liability claims, might play a bigger role in this regard. They also play a very big role when you think about the damaged third party that might want to bring direct claims against the device manufacturer or the software developer. For example, if company A does not have enough financial stability to fulfill such a claim, or for any other reason. So, and in this regard, then you have to think about what kind of action you can bring and what are the key hurdles in such a case. Yeah, you have to overcome if you're a claimant, or if you look at it from a company perspective. Yeah, so what are the main defense lines you have in order to avoid liability in such a case? And I mean, there are standard, so usually there are typical lines of defense. Yeah, you try to invoke. So the first line is whether software can really be seen as a product. Yeah, because product liability, at least from a classical understanding and perspective, meant hardware products, products that are physical, that you can really touch and grab. And so the question is, for example, for the software developer, is it really a product he's putting on the market? And under the still existing standard, there was at least a lot of discussion going on, even though the majority said software should be seen as a product. It was disputed until up to date, and now, so the new regulation, we will see that in a moment, makes it crystal clear that software is to be seen as a product, because it's getting more and more important, and more functions are driven by software instead of hardware. Another key question is, of course, is the software or the hardware defective? Does it not comply with the safety standard that it should comply with? And is there a chain of causation between the defectiveness of the product and between the damage that has been caused? Was it a malfunction, or was it a misuse maybe by the worker who used the system in our example? And then, of course, the burden of proof in these cases is a very important point, because usually in at least continental Europe, litigation, the person who brings a claim or the company brings a claim has to provide evidence for all the relevant facts and circumstances that bases the claim. And so if you cannot look into the software details and not see into it and see that there might be something wrong with it, or into the details of the hardware, then it's often very tricky and difficult for the claimant to bring such a claim. And so it's rather easier for the manufacturers to defend themselves in such an action. Now, what has been changed on the European level with regard to the new law? So first of all, and I touched this point already, software is now clearly falling under the term product. So it's no longer any type of defense line you can take. And it goes hand in hand with all the other changes we have seen over the last couple of years in European law, because also when it comes to the sale of products and stuff like that, then there was this term goods with digital elements in it. So goods that only function in a proper manner if the digital component of the product is also properly working. And so the European lawmaker clearly put this software part of products and software as a standalone product within the scope of the term product. Then, in addition to that, when it comes to the safety expectation, so again, the question, was the product effective or not? Was it matching the safety expectation? Then up to date, you only looked at the user group and thought about whether it matches the expectation or not. Then, as Moritz said before, also in another context, you looked at how it was advertised, how it was described on the market. And that was the basis for this analysis. But now the standard is changing in this regard. So you do not only look at the user group, it's still relevant, but you also look at the general public. So in particular, in a case like we see here, where you have often public environments which are affected, that might play a relevant role and might lead us to a situation where the safety expectation is much higher than under the existing standard. So this means when designing the product, you have to take even a closer look on the product and see whether you can mitigate risks for the public by taking additional safety measures. So when we look at the example from Moritz with the truck and the glasses from Apple, then you can critically ask the question whether there must be kind of a function included that if the hardware is seeing that a fast movement is happening, that it automatically deactivates or something like. Of course, this also limits the function, because if you want to sit on the back of a car, then something you want to have as a function. So this is why these questions then are very difficult to answer and to find the right balance between usability and between mitigating risks for the company. But just wanted to give you kind of a flavor in what direction we are heading here in this regard. Then, of course, cybersecurity is a big issue now under the new regulation, and you can imagine that cybersecurity with all the software included and so on, it's of course a very relevant point also for the VR, XR, and AR devices. Also, the relevant moment in time, and I skipped part of here because of our limited time frame, but the relevant moment in time when it is decided whether or not the product is seen as defective, which is usually the placement on the market as of today. This time period is significantly pushed forward, because if you have still access to the product as a manufacturer, like over the air updates you can install, then it's no longer the placement on the market, so the original sale of the product, but it's the point in time where you no longer have access to the product. So this means if you have kind of a functionality where you can upload updates to the software of the device, then this means that you have to continuously provide updates in order to have a product which is matching with, for example, the cybersecurity requirements and other requirements. So this is something which you definitely have to take into consideration when thinking about a use case for your product, a business case for your product, how to advertise the product, how to design the product. So at a very early stage, and if you don't do so, then of course the business case can be scrutinized quite easily. Also, data is now seen as a protected good. That was nothing which was covered under the existing law, but now it's clearly stated that data is qualified as protected legal interest, meaning that damages have to be paid if there is a loss of data. The calculation of compensation in this case is up to the member states. So we will see in the course of the implementation, as described before, the period is still running, the 2 years period, what specific method will be applied by the different member states, but there will be kind of a calculation. And we see already a lot of cases where data scraping and stuff like that is used as a basis for bringing mass litigation, also in Germany, but also in other countries. And you see that more and more claimant firms are pushing these things forward. Then when we look at the level of how to provide evidence that there is, for example, a defective product, a defect in the product, or that there's this chain of causation between the defect and the damage, the harm that has been caused, then it's now getting easier for claimants to bring such actions and to provide evidence in this regard, because there are two things that materially change compared to the situation as of today. So the first thing is that we have a very broad duty of disclosure for the manufacturers, meaning that the court in case of an application of the claimant can order the manufacturer to provide all kind of relevant documents and relevant documentation like drawings, like risk assessments, other discussions you had internally about the product and how to design and frame the product. And this, of course, is very dangerous, because that means that, again, at a very early stage of the production process and design process, you have to think about how to structure your documentation, what to put in writing and what to better not put in writing. So this is something which should definitely be kept an eye on when manufacturing products in this regard. Then, in addition to that, there's another material change, and we call it here facilitation of evidence. So in principle, it's kind of a statutory presumption. So the defectiveness of the product is presumed in case the defendant either fails to provide the relevant evidence, in case there is such an order of the court and such a duty exists. So what I told you on the previous page. Or in case that the claimant demonstrates that the product does not comply with mandatory product safety requirements laid down in union or national laws. So this is where we come to cybersecurity requirements. This is where we come also to the product liability directive, as we discussed before, and the applicable standard in this regard. Or if the claimant demonstrates that the damage was caused by an obvious malfunction during a reasonable foreseeable use or under ordinary circumstances. So you see in all these cases, there's a change, a shift in the burden of proof. And so in case the manufacturer, the defendant will say, no, I'm not liable, they have to provide evidence, all the documentation, and have to provide substantial facts to show that, the product was not defective at all. There's also a presumption of the causal link between damage and the defectiveness of the product. And this is the case if the damage that has been caused is kind of a typical damage that is consistent with the defect in question. So a typical damage, you can hardly think of a broader description than this. So also in this regard, the burden of proof has more or less shifted to the defendant instead of the claimant. And if you look at cases in which technical or scientific complexity exists, and I mean, in all these cases, we think about here virtual reality, augmented reality, AI use, and stuff like that, complex hardware with software integrated function and stuff like that, you always have this requirement present. Then in this case, the presumption goes even beyond that, because in this case, it is sufficient that the claimant demonstrates that it is likely that the product is defective, or that there is a causal link between the defectiveness and the damage, or both. And this likeliness is really reducing the standard again significantly, which means that more or less in all these cases we can think about here, we have a situation where the manufacturer, the developer, the user of the product will have to defend it and provide evidence why everything was fine with the product, with the software and stuff like that. So this means you really have to think about from the very beginning about defending these cases once they come up, because you cannot produce evidence at a later point in time. This hardly has a lot of credibility in a court proceeding. So you really have to document things from the early design phase through the manufacturing process and through the adaptations and updates you provide for the product. When we speak about user safety, so this was the part product liability, and I hope you get some flavor about what's going on in this regard and why this is particularly affecting the VR, AR, and XR world. When we speak about user safety, I want to touch two relevant points here. So first of all, we have some principles that apply in this regard. So the employer has to take the necessary occupational safety measures, which is part of the Arbeitsschutzgesetz in Germany, one of the very central legal norms when it comes to the protection of the workforce. And in order to determine what kind of measures must be taken, there has to be a very comprehensive risk assessment of the workplace and whether the workplace meets all the statutory requirements. And then once this risk assessment has been done and the workplace has been put in an appropriate status, then the employer must also provide the employee with adequate and appropriate instructions on safety and health protection. So not only provide a safe environment, but also advise the employee about how to safely navigate this environment. And now coming to XR systems or AR systems and even VR systems, you can imagine that this is changing the way how people work significantly. And so in this regard, you have some specific hazards you have to keep in mind. So for example, eye strain is an issue if you are working a lot with virtual glasses, for example, or augmented reality. For some people, it is not so easy to cope with that. Also motion sickness and stuff like that might derive from this, the use of these products. Then psychological effects in this regard that must be taken into consideration, and of course all the indirect hazards. So if you're working with augmented or virtual reality classes and you have no proper environment and might fall or might end up hitting a wall. I know that these glasses have typically a lot of safeguards implemented in this regard, but still you see cases in which for the one or other reason do not really do their job or work. So this is also something you have to take care of. And so you see now we are speaking about labor law and labor protection, and this is a totally different field of law, and still the AR, XR, VR systems and the legal regulations that are in place in this regard have to be taken into consideration, and have to be taken into consideration to some extent also when you are the one who are designing these products, because the more you can avoid by design, the easier it is for the employers to implement then these new technologies in their companies. And so this is always something where maybe not necessarily if you're in a position of a mere manufacturer, but still it might be reasonable or good to think about these issues when designing the product, because then you will have a better business case and can make a better business case out of it. This closes my comments on product liability and occupational safety. And for the final part, Moritz, I will back hand over to you.
Thank you very much. And just looking at the time, I would, Samuel, if we can, thank you for your question. I would quickly want to try to give you a brief answer, which will be tough for me as a lawyer. But the short answer is there's no unique legal precedent set yet really tackling the situation you described, meaning you record something through an AR device, which is quite different, as you point out, technically from recording something through a phone or public video. And that's the challenge here, that we have old law applied to new technology. In the US, for example, the way we would argue this is we would say, well, that's if you record copyrighted material, you would display it, it's fair use. As you know, fair use is being determined by US courts on a case-by-case basis, so that can be tricky. The good news is it's rather hard to find a case, because you see it through your glasses, but you don't display it through your glasses to others, and you see it for a second, which is not a constant reproduction that is very easy to pinpoint and then attacked with the lawsuit. But with that, we wanted to end our presentation with emerging legal trends, talk about AI, obviously, but without catfishing you and putting on the invite. And we wanted to end it with good news, frankly. Good news in terms of there are European regulations that are good news, that are easy, or like rather they're easier to navigate. Not easy, but easier. And that's, of course, the AI Act. AI Act, everybody talks about AI. We wanted to start with what is an AI system under the EU AI Act. And you have this fantastic description and definition here, which I was very happy to see as a lawyer at the beginning until I read it. And then I realized, well, that's pretty much everything. So on the right side, you see a short condensed summary, which is the way we think about it, and maybe it helps. AI is any system that's designed to operate with some level of autonomy and uses input to generate output. So the real threshold is some level of autonomy. It's all predetermined, set rules, no AI, the rest. It's very, very broad and it's covered by the EU AI Act. The good news is, and to spoiler you, however, for most of the AI systems, the obligations are very limited. Why is that? Because the AI Act uses a risk-based approach. Everybody loves risk-based approach and everybody loves this pyramid, at least when talking about the EU AI Act, so I'm sure you're familiar with it. Real quick, the EU AI Act outlaws certain practices because it says they are so dangerous, we do not want them in Europe. What is that? For example, harmful AI-based exploitation of vulnerabilities. For example, exploiting the elderly or the young powered by AI. Or, and this can become more relevant for an XR and VR space, emotion recognition in workplaces and education institutions. I will touch about emotion recognition in a second again, because you can see it already below the practices that are outlawed. There are certain activities identified as high risk. If an AI practice is identified as high risk, it is subject to very strict obligations, both in development, but also throughout the life cycle. And here you see again, emotion recognition, especially used in education, for example, scoring exams, in the HR development area, and medical devices, for example. And then, if you do not do emotion recognition, don't use it in the HR area of education. For all the other practical use cases for AI, there are very limited rules. What are these rules? Transparency obligations and AI literacy obligations. We will touch on it really briefly, but it's overall the vast majority of AI applications falls into the green bucket. So yes, we have a very wide definition, but for most of the AI systems, very limited obligations under EU AI Act. It does not, of course, mean that all the other beautiful EU regulations wouldn't apply, so the GDPR applies regardless, even for the no to minimal risk AI applications. That's just as a side. So here, real quick about the prohibited AI practices, and apologies for the little art the test here, but you see essentially three buckets. One is the influence of emotions at work or education institutions. Here, the threshold is really, is it done by your employer? Is he really doing it on employees? If it's not in a work institution, at work or an education institution, it's not prohibited. Then, of course, manipulative techniques, that's outlawed, and exploitation of vulnerabilities. For example, to seduce little kids to buy star coins or something else in a video game to progress further and interacting with the AI, and it's convincing them to spend all the money because that's what they need to be cool. So you see, these are rather clear examples, except for the motion recognition. The motion recognition can be something, and VR glasses can do that. And it's a nice feature, but again, here it's only outlawed in Europe if it's at work or an education institution. But it doesn't mean it's possible without any rules, because we remember the tip of the pyramid was prohibited practices. Part right below it was high-risk applications. High-risk applications being subject to very strict obligations. And here we see one thing surprised me at the beginning. One of the purposes that the AI identifies as high risk is AI systems intended to be used for emotion recognition. There is no to then hire and fire people, or to then punish them, or to then seduce them. There's no link to another purpose. So that's what we meant here with there's no gaming exception. Because talk about the metaverse, I have an avatar, I'm wearing my VR glasses, I have a camera which is inverted inwards, sees my face, and I'm smiling because I like to smile. And wouldn't it be nice? My avatar smiles then as well, mimics my impressions. Of course, there are different ways to argue this, and that's why it's important marketing and documentation, like Eric talked about it. How do you describe the feature? Is it really emotion recognition? Is it emotion mimicking? Is it just measuring the left end and the right end of my mouth, and if both are upwards, it will display this? But this is a pitfall I wasn't expecting, so we thought it's helpful to point it out to you, in particular as it's a nice feature in applications and also for devices to really monitor how the user is reacting and then portray it. This can qualify as high risk. But again, we need an AI system. So if it's strictly rule-based, for example, if it measures just like here, identify the right and left end of the mouth, and if they're upwards angled, then you do the same with the thing, you can argue it's not the AI system. That's why marketing. If you say, oh, we are AI empowered, lawyers will say, look, it's an AI system. But that's just it. So we thought about what can be particularly relevant, and this is the use case that is the high risk one. But what about the rest? For the rest, we need transparency. Transparency is great, and it doesn't mean much here. First one is the end user, when interacting with AI, needs to understand that they're interacting with AI. Okay. In a virtual environment, if you talk with a computer, you can see it from the surroundings and they conclude it themselves. If it's not quite that obvious, they should be informed. And the second one is, to the extent the AI system generates audio, image, or video content or text, it needs to be marked in a machine-readable form as AI generated, as you can see on the right. And that's it. So the question is, what now? And here we just summarized again. We're looking at our beautiful pyramid again. Many, many applications can qualify as AI, but they're only very limited obligation for most of the applications. And for the high-risk ones, they're very strict obligations, and emotion recognition is a pitfall. When there was the period where the public could comment on the UI, different lobby organizations in Europe have commented and raised the emotion recognition issue. The EU Commission hasn't heard it and hasn't addressed it. So there's no real legal way out of this, and that's why we just wanted to make sure you see the iceberg when developing and when advertising these features. And with that, I can hand over to Eric, but wanted to say thank you again for your time and attention. Obviously, if you have any questions, we're always here.
Yeah, thank you also from my side. That brings us to the end of our presentation, and here just some information about further guidance you might want to get. So we have a podcast, might want to look into it. But Marc, back to you.
Thank you very much for some really interesting insights. I don't claim to understand it all, and that's great because that's why we have you guys available to do it. I did have one real quick question. We've literally have 2 minutes, and it's gone back almost to the start around the IP part, which I know is something that some of our members within the area are concerned about. So, yeah, how could or should enterprises manage IP rights and licensing when they're kind of creating or using XR content that's been developed by a third party? And that's quite often the case. Not all companies can develop their own content. So what happens there? Can you talk a little bit about that and the IP protection?
Obviously. And the first win is already when you identify the problem. When you identified, okay, where is the copyrighted material information that you're using, and then to ensure that you have a license. Or that you have, for example, in the US, a fair use exemption that allows you to provide it. Because usually the cases we see in Europe is the topic of copyright gets raised rather late in the process, and then it's rather hard to then identify, okay, where the license, can we get the agreements, can we make sure this? So it's really, really important to, like, whenever something is processed, whenever something could be copyrighted, to really identify it and then involve legal, either externally or internally. As the beauty is, copyright is a very old topic and it's a new technology, but it's very open to technology. But thank you for your question again, by the way, from the colleague from Boeing. There is no clear legal precedent, which makes it harder. There is no XR exemption that would make our lives, particularly your life, of course, easier.
Perfect. Well, I think we're going to have to leave it there, gentlemen, because I'm sure people have got other calls and things we're doing. But thank you very much. And it's been a pleasure listening to that talk today. So thank you very much, gentlemen, and thank you everybody for joining today.
Thank you.
Thank you. Have a good
nice day.
Bye.
Thank you. Bye.